Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is actually my AI avatar, presenting from a script that I've personally written and approved. If you're a startup founder or a business owner looking to raise capital in Australia, it's essential to understand your legal obligations before approaching investors. Because under the Corporations Act, failing to comply with disclosure requirements isn't just a technicality. It can result in strict liability offenses, civil penalties, and even force you to refund the investor's money. Today, I'll explain when disclosure documents are required, what must be included in them, what exemptions apply, and the key things you must know to stay compliant when raising capital. Under Part 6, D.2 of the Corporations Act, if you offer securities, and that includes shares, options, convertible notes, or safes, to investors, you generally need to issue a disclosure document. This document must be lodged with ASIC before the offer is made, and it serves as the primary source of information for your investors. It's designed to ensure transparency, accuracy, and accountability. In short, it's the legal foundation of your fundraising. And failing to prepare or lodge it correctly can invalidate your offer entirely. The disclosure document needs to clearly identify who you are, what you're offering, and why you're raising funds. It should include a description of your business operations, the type of securities being offered, how the funds will be used, the risks associated with investing, all costs and fees payable by investors, confirmation that the document has been lodged with ASIC, and your latest financial reports and performance indicators. Everything in the disclosure document must be accurate, complete, and not misleading. Leaving out material information, even unintentionally, can amount to misleading or deceptive conduct by omission. That's a serious breach under both the Corporations Act and the ASIC Act. Not every capital raise requires a disclosure document. The law recognizes certain exemptions, the most common being for sophisticated investors under Section 708 of the Act. This exemption applies where an investor puts in at least $500,000 or where they hold a certificate from a qualified accountant confirming they have net assets of $2.5 million or an annual income of at least $250,000 over 2 consecutive years. The rationale is simple. Sophisticated investors are deemed capable of understanding and managing their own risks without needing the same level of disclosure as retail investors. But here's the catch. If your investors don't fall within these exemptions and you still proceed without a proper disclosure document, you could be in breach of the Act. And that means the investor may have the legal right to demand their money back. If you're raising capital, whether through shares, convertible notes, or safes, make sure your investors fit within an exemption like Section 708, or issue a valid disclosure document. If a disclosure document is required, it must be verified by both a lawyer and an accountant. Every statement, forecast, and piece of information should be based on evidence. And if circumstances change before the investment is finalized, you must correct or update your disclosures. Otherwise, your earlier statements could become false or misleading. This applies whether it's a change in business projections, new financial data, or any material development that could impact an investor's decision. Failing to do so doesn't just risk litigation, It can expose you to serious regulatory consequences under the Corporations Act, the ASIC Act, and the Australian Consumer Law. Raising capital isn't just about winning investor confidence. It's about ensuring legal compliance and transparency. Whether you're offering shares, safes, or convertible notes, understanding your disclosure obligations under Australian law protects both your business and your investors. At Leo Lawyers, we help startups and growing companies navigate capital raising with confidence, ensuring your documents meet every legal requirement and your investors are properly informed. If you'd like tailored advice for your next capital raise, you'll find our contact details in the description box below, or visit us directly at leolawyers.com.au.